Equal Rights Amendment, Biden's declaration and the ongoing debate. Introduction. President Joe Biden recently reignited a decades-long debate by declaring the Equal Rights Amendment, ERA, as the law of the land, labeling it as the 28th Amendment to the U.S. Constitution. While this statement underscores a significant push for gender equality, it also raises important questions about the legal process and procedural hurdles surrounding constitutional amendments. Let's dive into the history, recent developments, and the controversies shaping the ERA's future. Historical context of the ERA. The Equal Rights Amendment was first introduced in Congress in 1923 by suffragist Alice Paul. It sought to ensure equal legal rights for all American citizens, regardless of sex. The idea gained significant traction during the women's rights movements of the 1970s. In 1972, Congress passed the ERA with bipartisan support, and it was sent to the states for ratification. To be added to the Constitution, it needed approval from 3/4 of the states, 38 out of 50, by a deadline of 1979. Despite early momentum, the ERA fell 3 states short, and Congress later extended the deadline to 1982. However, even with the extension, the required threshold wasn't reached. Recent developments. Fast forward to the 21st century, the ERA saw a resurgence. Between 2017 and 2020, Nevada, Illinois, and Virginia ratified the amendment, bringing the total to 38 states. Supporters hailed this as a victory, claiming that the ERA had met the requirements for inclusion in the Constitution. However, there are legal complications. The original 1982 deadline had long passed, and several states that initially supported the ERA, such as Idaho and South Dakota, rescinded their ratifications. These rescissions further muddy the waters of whether the ERA is legally valid as an amendment. President Biden's declaration serves as a symbolic endorsement of the ERA. "We must affirm and protect women's full equality once and for all," Biden said. While his words carry moral and political weight, they do not have the legal authority to bypass procedural requirements for amending the Constitution. Legal and procedural challenges. The National Archives and Records Administration, NARA, is the federal agency responsible for certifying constitutional amendments. NARA has taken a cautious stance, stating it will not certify the ERA without explicit direction from Congress or the courts. Furthermore, federal courts have dismissed lawsuits aimed at compelling the archivist to act on the recent ratifications. They point to the original deadline set by Congress and established legal precedents that amendments must adhere to these timeframes. Adding another layer of complexity, the issue of states rescinding their ratifications remains unresolved. While some legal scholars argue that rescissions are invalid, others contend that states have the right to change their positions before an amendment is finalized. Biden's role and political implications. President Biden's declaration is part of a broader strategy to put pressure on Congress to act. Advocates are calling for lawmakers to pass a resolution removing or extending the ERA's ratification deadline retroactively. However, this effort faces stiff opposition in a divided Congress, particularly among conservatives who argue that the ERA could lead to unintended legal consequences. For Biden, the ERA aligns with his administration's broader commitment to gender equity, as evidenced by his policies on reproductive rights, workplace equality, and combating gender-based violence. By taking this stance, Biden seeks to galvanize public support and draw attention to the amendment's significance in achieving equal rights for women. Public and cultural significance. The ERA's potential inclusion in the Constitution carries immense symbolic and practical importance. On a societal level, it represents a formal acknowledgement of gender equality. Legal experts argue that it could strengthen protections against gender discrimination in areas like employment, education, and healthcare. Critics, however, warn that the ERA could be used to challenge restrictions on abortion or single-sex facilities, sparking concerns over its broader implications. These debates reflect the enduring divide in American society over gender roles, rights, and legal protections. The path ahead. The future of the ERA remains uncertain. Congressional action to remove the deadline would require bipartisan cooperation, a challenging prospect in the current political climate. Additionally, any resolution is likely to face legal challenges, potentially leading the issue to the Supreme Court. For supporters, the fight for the ERA is far from over. They see Biden's declaration as a rallying cry to continue pushing for equality. As the nation debates the amendment's validity, the ERA serves as a reminder of the ongoing struggle for gender equity in the United States. Conclusion. President Biden's bold proclamation has rekindled the ERA's promise and controversy. While the legal and procedural hurdles remain significant, the debate itself reflects broader societal conversations about equality, rights, and the Constitution's role in modern America. The ERA's journey, nearly a century in the making, is a testament to the enduring fight for justice and inclusion.